Welcome to a Law Shelf case study on Domingo versus Mitchell. This is another case study in our ongoing series, and here we are presented with a case from the Court of Appeals of Texas. This is in Lubbock County, and it's a case from 2008 that's going to take a look at contract law, the elements of contract law, and some standards for a motion to dismiss. So let's begin. This is an interesting case where we're going to have a background of playing the lottery. And the old saying goes, you can't win if you don't play, and that's something that they're going to discuss today. So what happened in this case, we'll begin by giving you some facts, is Domingo and Mitchell were co-workers. They worked at the same company, and periodically they were part of a lottery group. You may have heard of a lottery group. It's when a number of co-workers get together, and instead of individually purchasing, say, 10 tickets, they will get a group of people together and purchase 100 or 200 tickets. And everybody gets an equal share in the tickets. So if one person wins, they all split the winning. And it gives everybody a greater chance at winning the lottery. So Domingo and Mitchell were part of this lottery group, and everyone would contribute a share of money to buy the Texas lottery tickets, with the agreement that if they split the money, if they won, and they'd split it equally. There was a leader of the group. Her name was Cindy Skidmore, and she even went so far as to form a limited partnership to run this lottery group. So she formed this entity, and the point of the entity was to take people's money and purchase the tickets. At some point, Skidmore emailed all the group members and asking if they wanted to take part in the group. Skidmore emailed Mitchell and specifically said in the email that if there's someone else you would like to invite, and you're pretty sure they won't drop out, please let me know. So in that email, she specifically solicited other members to join the group. As Mitchell thought about her friend Domingo, her coworker, and said, would you like to join our group, contributing to this group so that you have a better chance at winning the lottery? Domingo wasn't sure. So she said to Mitchell, well, how much does it cost? And Mitchell wasn't actually sure at that point either. So she says, how about this? I will cover your costs. I will lay out the money for you, and then you can pay me back later. So I know you're good for it. You can pay me back for it later. And Domingo says, Domingo claims at least that she said, yes, I told her, please cover my share. I'm in. I'm interested in the group. All the members of the lotto group meet in a restaurant. And the idea is that they're going to meet in the restaurant and they're going to pick which numbers to play. Now, the odds of winning the lottery at this point are about 1 in 175 million. But the more tickets they have, the greater chance you have of winning. So they sit around and decide which numbers are we going to play. They meet in this restaurant to try and decide which numbers they're going to play. And Mitchell was there, but Domingo was not. She couldn't make it to the lunch. So Mitchell pays her own share, which ends up being $17, but she did not pay Domingo's share. She says she didn't have enough money on her. She needed to also pay for her lunch. So she just paid her $17 and not Domingo's share. She said she didn't have enough money at that meeting. Wouldn't you know it, one of the tickets in the group wins over $20 million. It's a nice lottery win. If you can, as you can imagine, everybody wanted to say they were part of this lottery group. Now, the agreement was that they were going to split it equally. Domingo, however, wasn't given her share of the winnings because she never paid for the tickets, and Mitchell never paid her share. So all the members of the lottery group said, why should we have to share this with one more person? If we're all sharing it equally, if she's included, it will reduce our share, and we don't think she was ever included. She never paid her money. As you can imagine, Domingo was very insistent that she did, in fact, pay her share. What happens is that Domingo sues Mitchell for breach of contract. She says, "We had a valid contract. You agreed to pay my share of the winnings, and because you breached that contract by not paying for my share, you cost me the lotto winnings. The damages," she says, "I'm entitled to my share of the $20 million jackpot, minus the $17. I will pay you back for that share for my initial outlay that you said I was intended to cover." And the share became between $2 million and $3 million when it was all divided between the whole group. Now, Mitchell claimed that she was entitled to this money based on the concept of expectation damages. Expectation damages are a particular kind of damages that you can get when you're talking about contract law. There's a number of different damages you can receive. We'll talk about several of them today. Expect damages are trying to put the injured party back in the position she would have been in if the contract had been properly fulfilled. She says, if you had done what you were supposed to do and cover my share of the lottery tickets, I would be entitled to my share of the winnings. Therefore, under the theory of expectation damages, we have to behave as if the contract had been properly performed, and I should be entitled to those damages. She said, if you'd honored your responsibility, I would have gotten my share. Then all I'd have to do is pay the $17, and I would be an equal partner in the share of the lot. After Domingo files this lawsuit, Mitchell is not happy about it. And she says, you are not entitled to this share of the lottery, and I did not breach the contract. So she files a motion for summary judgment. She files this motion for summary judgment with two parts. One part is a traditional motion for summary judgment, and the second is what we call a no evidence motion for summary judgment. And we'll discuss both of these motions, and they have two different standards that the court is going to look at when evaluating whether the motion should be granted. In a traditional standard motion for summary judgment, what happens is the movant, the person who's making the motion, has to conclusively establish the absence of any genuine question of material fact, and that he or she is entitled to judgment as a matter of law. So in this case, what the court is going to look at is they're going to take a look at this motion and say, have you established that there is no material fact here? There's no question about it. That we really think you are, we don't need to go through and do a detailed look at every one of the facts because it's very clear on its face that you are entitled to win. That's how our standard for traditional motion for summary judgment. That will be applied in many cases when a traditional summary of judgment is moved, be it a contracts case or any other type of law that we're interested in. Once the movement has established that right, once they've made a clear showing that they're entitled to summary judgment, the burden of proof moves back to the non-movement, to the responding party, to say, hey, trial court, here are some issues that I can show you that preclude summary judgment. I have some evidence that where there really is a genuine issue. I think this fact needs to be looked at more carefully, and the moving party is not entitled to judgment as a matter of law. That's how it works for a traditional motion for summary judgment. Now, Mitchell also brought a no evidence motion. And in a no evidence motion, the movement contends that there's no evidence of one or more of the essential elements of the claim for which the non-movement would bear the burden of proof at trial. Essentially, this is saying that we have certain elements that need to be shown in order to prove that we had a valid contract, and we will discuss all of the elements of a valid contract in just a moment. And Mitchell here is saying at least one of these elements of a contract cannot be shown. There's no evidence that we have one of these elements. And if you can't prove all the elements of your case, then you can't make your case at all. With this standard, with the no evidence motion, the trial court has to grant the motion unless the non-movement can produce some competent summary judgment evidence or raise a genuine issue of material fact on the challenged elements. So unless the non-moving party can really show some genuine evidence to say, in fact, yes, there was an agreement, or yes, there was an offer and acceptance. So those are the two motions that Mitchell files in response to Domingo's concerns. Now, with this motion to dismiss, Mitchell moved on many grounds. She isn't simply saying, hey, you failed to show one element of the case. She claims that she cannot show several elements of the case, that there was no valid offer, there was no valid acceptance, there was no meeting of the minds, there was insufficient consideration given, and that there was not compliance with the statute of frauds. The trial court looks at this motion and tends to agree with Mitchell. They grant her motion for summary judgment, saying, we agree with you. Domingo cannot show these claims. She has not met her burden to show that she's satisfied all of these elements. And we agree with you. Grand motion of summary judgment granted. Domingo appeals. Now, on this appeal, it's important to note from a procedural perspective that the standard the court is looking at on this appeal is not who should win the case. The court isn't really trying to decide who's actually should win here, but whether any of the grounds were so clear as to make summary judgment warranted. So they're really looking at whether or not the trial court behaved appropriately in granting the summary judgment motion, or did they look properly at the evidence? Was there some evidence that means, well, we should have looked more closely before granting summary judgment? In order to take a look at this, we're going to do some background in breach of contract because it's important to have some understanding of the elements of a contract to know whether or not the parties actually met their burden. To do this, we're going to take a look at all the elements that somebody must prove in order to show their claim of a breach of contract. The first step is knowing what you need to prove to show that you actually have a valid contract. The basics of contract law, Contract 101, is that for a contract to exist, there must be three things: an offer, acceptance, and consideration. And we will go into detail about how you can have a valid offer, acceptance, and consideration. Most people think of a contract as a written document, and very often that is the case. But we're also going to talk in this case about the existence of oral contracts. And when you can have a contract, a valid contract, enforceable contract that just exists based on the parties' oral communication. And the existence of an oral contract may be proved by circumstantial evidence as well as direct evidence. In order to determine the existence of an oral contract, the courts are going to look at the communication between the parties and the acts and the circumstances surrounding those communications. So they're going to take a look at what the parties, how they were behaving, what they said, and all of the communications. Sometimes maybe they gave a handshake or a nod or some other communication that somehow indicates that they have this contract. And the court will look at all of those when determining if there is an oral contract. We also have to look at the other elements. We have to look at whether there's an offer and acceptance. And in this case, and a meeting of the minds, the courts are going to use what we call an objective standard. That really means they're going to look at what would a party who observed this scenario think about this situation. If a party were to look at the communications or hear the communications between these two people, would they, an outside party, think that a contract exists? So instead of looking at a subjective perspective, whether the parties in their own mind thought they had an agreement, we're going to say what objectively really happened. Does it really seem from an objective standard that a contract exists? And that's the standard that the court will use when trying to determine if the parties really have a valid offer and acceptance. In order to prove a breach of contract, we have several elements that need to be proven. One, the existence of a valid contract. Two, that performance or tendered performance by the plaintiff, that the plaintiff actually lived up to his or her end of the bargain. And that there was a breach by the defendant, that the defendant did not live up to their end of the bargain. And damages. In this case, $20 million worth of damages. So when we focus on this case, we're going to really look at that first bullet point and whether there was a valid contract in the first place. It is clear that the plaintiff didn't participate. It's clear that the defendant didn't pay for her or give her a share of the earnings, and it's clear that there were damages. So the questions here is really going to be that first element and whether there is a valid contract. So we begin with the first element of a contract, the offer. And with each step of this process, we are going to use a form called IRAC. You may be familiar with this process. It is a very common process in legal writing or legal reading where we will lay out the rule. We'll talk about what the law says about when we have a valid offer, and then we'll take that rule and we will apply it to the given facts. We'll do the application. And it's a great way to really say, here's the rule, and how does that apply in this particular circumstance? So we'll start with the offer. When it comes to an offer is considered an expression that indicates an intent to be bound by a contractual agreement. So really an offer is a way to say, if you accept this, I agree to be bound by it. Here's what I want to happen. I am offering you something that I hope to become a contract. It has to be specific and definite enough for a reasonable offeree, that's the person to whom I am offering the contract, to believe that the offer intends to be bound by the contract. So we will often look at the offer and say, was that sufficient? Did the offerer intend to be bound? One of the ways to determine whether the offeree intends to be bound is to look at a situation when it's clear that the offeree did not intend to be bound. And there are certain circumstances that the courts have agreed upon really do not constitute a valid offer. Things like an expression of interest. An expression of interest is when somebody will just sort of indicate, hey, I might be interested in that, but not a firm offer. So if a friend were to say to you, hey, how old's your car? I'm looking to buy a car of that model. Are you interested in selling? It might be clear from this that your friend might possibly be interested in buying your car or looking at your car, but there certainly is not enough specifics to constitute a valid offer. That's just an expression of interest. Or perhaps it's an invitation to negotiate. Would you like to discuss selling your car? Are you open to discussing whether we could agree on a price? It's not very definite. It doesn't give a specific price term or a timeline or any real commitment. You couldn't say, a reasonable person couldn't say from that communication that somebody intends to be bound to buy the car. Another one is advertisements. If a department store puts in the newspaper or online an ad that says sneakers for sale, $40, and you run down to the store and it turns out that that pair is unavailable or at a different price point, and you say to the store, well, you made an offer to sell me those shoes for $40 and I accepted the offer. The fact that you don't have them means you're in breach of contract. it doesn't work like that. Then stores would very often be in breach of contract. So advertisements are regularly considered as not official offers. They do not constitute a valid offer. Additionally, an expression that's so vague that a reasonable person could not pinpoint the terms of the potential agreement. So again, the court's really going to look at how reasonable was it? How much would one person really consider themselves bound to a contract based on the terms that are given? So with that rule in mind, we'll take it and we'll look at the situation that happened here. We'll do the application. Mitchell's argues that the offer here was not valid. And she says this for a couple reasons. Number one is the price. She says, we didn't specify a price in this offer. I never offered to cover a specific amount. I never even told her what that amount would be. So how can you say I have a valid offer and that I'm bound to this contract, that I promised to be bound by the specific contract when I never even knew how much it was going to be? And furthermore, she says, Domingo was never asked to submit numbers for the drawings. These parties, if you remember, they got together and they all agreed upon which number they were going to play in the lottery. Incidentally, the number 38 has historically been the most chosen number in the lottery. For whatever reason, it gets chosen more than any others. So, lucky number 38 for anyone wanting to play. But Mitchell says, Domingo never gave us numbers. She was never asked to submit numbers. That wasn't part of the offer, and that's an essential element. The court disagrees. They say, when it comes to the price can be inferred from the circumstance. So what happens sometimes is we have something called the Uniform Commercial Code. And the Uniform Commercial Code, or the UCC, which applies to merchants in the process of selling goods, says that we can sometimes fill in these gaps. That a contract doesn't even have to have the price term sometimes, if it's reasonable that we can figure out what the price might be. So in this instance, for example, the parties weren't very exactly clear how many people were going to participate in the lottery pool. Maybe they didn't know exactly how many tickets they intended to purchase. So the price might have varied. Everybody in the pool may have agreed to be part of the pool before knowing the exact price. Furthermore, the court says submitting numbers is really not part of the offer. The court says it really is not. When we say, do you want to be part of this lottery pool? The response isn't, I want to be allowed a part of the lottery pool and my numbers are 16, 12, and 24. Or do you want to be part of the lottery pool and give me the numbers that you would like to play? That is not part of the offer. The court says that really is not an essential element of this contract offer. And even without that, we can infer that there was a valid offer here. So as we go through and we look at the essential elements of a contract, when it comes to offer, first, the court says, yes, we have a valid offer. At which point they turn to look at acceptance. So acceptance is the next step after an offer. Once a party makes a valid offer, the offeree has the power to accept it. And an acceptance can come in a number of forms. It can be express or implied, meaning I can expressly say, yes, I would like to accept your offer. That is express acceptance. Or I can imply it with my actions. Maybe I nod my head, or I shake your hand, or I somehow imply that I want to accept the offer. It can be verbal, it can be in writing. So there's a number of ways that I can accept your offer. All the acceptance has to do is be a reasonable indication that the offeree agrees to be bound, once you've given me the valid offer, I have to indicate in some reasonable way that I intend to accept it. I also want to be bound by this contract. In this case, we have what's known as a bilateral agreement. A bilateral agreement is when the parties exchange a promise for a promise. So I promise to wash your car if you promise to give me $50. That is in exchange of a bilateral agreement, a promise for a promise. And when we have a promise offered, acceptance must be the return promise. So I promise to cover the cost of your tickets if you promise to pay me back. Additionally, acceptance can also be gleaned from the conduct of the parties. So sometimes instead of actually agreeing expressly to be bound, I may behave in a way. So if you say, I promise to pay you $50 if you wash my car, and I go ahead and wash the car, then it can be inferred from my actions that I have accepted your offer. It is clear that I've accepted your offer because I've gone ahead and performed. I've done the thing that proves that I've accepted your offer. So that's the rule on when we have a valid acceptance. And now we can go ahead and apply that to this case at hand. So in this case, Domingo claims that she and Mitchell frequently participated in lottery pools with coworkers, that this wasn't the first time they've behaved this way, that everybody knew how this lottery pool system worked. It wasn't the first time we've done it. And so really, this is how this acceptance worked. You say, do you want to be part of it? I say, yes, will you cover me? Because I can't make the meeting. Now remember, for purposes of this case, we are not trying to prove whether the contract actually existed. We are trying to prove whether this motion to dismiss should have been granted. And when you go through to look at a motion to dismiss, you have to accept all allegations as true. So Domingo says we frequently participated in the lottery pools. The court in this case isn't going to go back and say, well, did you frequently participate in lottery pools? Can you show me evidence of how many times you've participated in lottery pools in the past? And how many is frequently? How often? That's not the analysis the court is going to do here. They are going to accept all these allegations as true, saying, okay, if you did frequently participate in lottery pools, and if you did do all of the things you say, do we have an acceptance? Is that enough to show each element of the contract here? In fact, here another coworker says, I was there when Mitchell agreed to cover Domingo's share of the lottery drawings. That yes, she did promise to cover her share. I was there, and I know that's what happened. Furthermore, Domingo says that after they had this lunch meeting to pick the numbers, Domingo said to Mitchell, why didn't you pay my money? It's $17. Did you cover me? Mitchell says, I didn't cover you. And Domingo says, why not? Why didn't you pay my money? And Mitchell responds by saying, I didn't have enough money last night. She doesn't respond by saying, I didn't think you wanted me to, or I didn't think you intended to participate in the lottery. She says, I didn't have enough money. She had to pay for her lunch at the restaurant, and she had to pay her own $17. And she indicates here that if she did have the additional $17, maybe she would have covered Domingo's money. So Domingo is using this to show her point that, hey, really, you just didn't have enough money. You would have covered me because you knew I had accepted your offer. You offered to cover me. I clearly accepted. I even followed up with you on it to see why you hadn't behaved as you'd promised. So the other question, so the courts will say, yes, there was an acceptance here. The next element that the court is going to look at is what we call a meeting of the minds. And a meeting of the minds is exactly as it sounds. We want to make sure that the parties in this case are both thinking the same thing. Remember, we're going to look at a reasonable standard, an objective standard, to say, is it reasonable to interpret a contract out of the circumstances that we have? Would both parties, or even an observing party, think that they have a valid contract here? So, when we have a meeting of the minds, it's thought of as a mutual agreement between the parties and their understanding of that agreement. They both have to have understood the same central terms of the agreement. So, if, for example, the contract called for the sale of a Mustang, I agree to sell you a Mustang, you agree to buy my Mustang. But one party thought that was a Ford Mustang car, and the other party thought we were referring to a Mustang as a horse, then we did not have a meeting of the minds. Clearly, those parties would not be on the same page. They weren't thinking the same thing. So that's what the court is looking for. Are these parties in agreement on the essential elements? Essential elements does not mean every possible provision. They don't have to agree on every single term of the contract in order to have a meeting of the minds. The court is going to use these gap fillers, they call them. We're going to use some interpretation rules, and sometimes when these certain information is commonly left out, the court is going to fill them in and use common rules of interpretation to fill in the elements that we think might be missing. In order to have a meeting of the mind, all we have to have are the essential terms that must be specified by the parties. We need to know if we're both talking about a car or we're both talking about a horse. We need to make sure that we're both clear on the basics of the contract. And if there's some little things left out, that can get filled in along the way. Remembering that the little thing that gets left out can even be the price. The courts will very often, infer the price. Even though it might not sound like a little thing to be left out, that can be filled in as well. So the question becomes, well, with that understanding of a meeting of the minds, do we have a meeting of the minds here? Mitchell argues absolutely not. We had very few details nailed down. We can't say there was a meeting of the mind. We didn't know what numbers we were going to play. We didn't know how much it was going to cost. There was no meeting of the minds to be here. We couldn't have possibly both agreed to the same thing. She says, especially because she didn't submit these numbers. That shows that she never assumed the agreement was in force. If she thought that we really had an agreement, she would have contributed her numbers. She would have told us what numbers she wanted to play. The court, however, disagrees. The court says this was not their first time. They all know the drill, right? They've done these office lottery pools before. Somebody organizes it, sends out who would like to participate. Everybody contributes their money. Some people contribute numbers. One person buys the tickets. If somebody wins, we share the earnings. They've done this before. She says we don't have to have every single detail nailed down, and the offer and acceptance and the meeting of the minds did not require knowing the exact numbers we intended to play, or maybe how many tickets we were going to buy, or which day's lottery we intended to participate in. We don't need all those details. The essential elements of this contract are pooling our money to buy a lot of lottery tickets, and that these two parties were clearly on the same page when it came to that. Picking the numbers wasn't a key element. In fact, by the rules of this group, you didn't even need to submit your numbers. Everybody wanted to pick certain numbers. Not everybody's numbers were going to get picked. And so if you didn't send in any, it didn't matter. The numbers were going to get chosen anyway, and the tickets were going to get purchased. So that idea of sending in your numbers and picking which numbers you wanted really was not an essential element of the contract. The next element the court is going to look at is a critical element in contract law called consideration. And consideration is the idea that in order to be bound to a contract, each party must agree to incur a legal detriment. Each party must give something up. And this comes in a couple ways. Either I agree to do something that I'm not legally obligated to do, or I agree to refrain from something that I am legally obligated to do. Typically, consideration will very, very often be your form of payment. I agree to pay you $50. I am not bound to pay you $50. There's no reason that I have to, but I agree that I will in exchange for you washing my car. You are not legally bound to wash my car, but that is what you are giving up. You are giving your services. I am giving money. You are giving me your car, and I am giving you your money. I am buying your house, and you are giving me money. Whatever it may be, that is typically each party has to give something up. Very often, consideration can be the idea that I am giving up the right to sue. So if a party says, when parties settle, if they're in a dispute and they agree to settle the dispute, essentially what you're saying is, I have the right to sue you for breach of contract. And the other party says, well, I will pay you X dollars if you agree not to sue me. And I say, okay. The legal detriment you have given is money. The legal detriment I have given is I have given up my legal right to sue. So that will very often be a form of consideration as well. In a bilateral agreement, remember that's an exchange of a promise for a promise, each side must make a promise to incur some form of consideration in order for the agreement to be binding. In a unilateral agreement, one side makes a promise, which the other side accepts by performing. So the difference here between your bilateral agreement is I promise to pay you $50 if you promise to wash my car. It's a bilateral agreement. Versus I promise to pay you $50 if you wash my car. And then when you wash my car, I pay you. That's the difference between a bilateral and a unilateral agreement. So additionally, one issue with consideration is that the courts aren't usually going to look at whether consideration is actually fair or adequate or equal. What the parties are bargaining, I will go back and forth and say, I will buy your car for $1,000. And you say, no, I want $1,500. I say $1,200. You say $1,300. I say deal. We have bargained for what everybody finds acceptable. You think it's acceptable to sell your car for $1,300. I think it's acceptable to pay that much for your car. Now, what if the comes in and the court looks at the car and the court says, $1,300, this car is worth much more. This car is worth $20,000. $1,300 doesn't seem reasonable. The court doesn't really care. It doesn't matter if the consideration is adequate. It only matters that both parties bargained for it and agreed to it. Sometimes people make a bad deal And the court is not in the business of overturning bad deals. They're just in the business of making sure that everybody gave up what they agreed to and what they bargained for. So in this case, when we look at consideration, Mitchell claims that Domingo didn't pay anything or promise to, and there's no consideration. She says Domingo didn't give any legal detriment. She didn't give up something that she could do, or she didn't give anything. The court disagrees. They say mutual promissory obligations by the parties to the agreement furnishes sufficient consideration to constitute a binding contract. The evidence here really shows that Mitchell agreed to advance her share of the lottery tickets, and Domingo agreed to reimburse her. I promise to pay your lottery tickets. I promise to pay you back. So, the courts have now looked at offer and acceptance and meeting of the minds and consideration. And in all those instances, the court have found that there really is enough evidence to think that maybe we do have a valid contract. Maybe we do have an offer and acceptance and a meeting of the minds and consideration. That when it comes to whether or not this motion to dismiss should have been granted, it seems like maybe there is evidence of a valid contract, or at least enough that we should probably consider it. But Mitchell's not done there, and she has one more issue that she would like to discuss, and that is called the Statute of Frauds. The Statute of Frauds is a rule that discusses when we can have a contract that is oral or when it needs to be in writing. As mentioned earlier, it is very common to have a contract that is not written down, that is just an oral contract. Two parties speaking can make a sufficient contract, even if they never actually write down the specific terms. But there are some cases that the court has determined where it is required that we have a writing. We need to be sure enough of the contract in these circumstances that the court requires it to be in writing, and that an oral contract is not sufficient. So the Statute of Frauds requires certain contracts to be in writing. We'll list them here, and then we can go through and discuss several of them. Contracts incapable of being performed within a year, contracts for the transfer of interest in real estate, contracts in consideration of marriage, like a prenuptial agreement, contracts to guarantee the debt of another, contracts to pay the debt of a decedent, contracts for the sale of goods for $500 or more, and some states add others, such as things as insurance contracts. So we'll just take a few of them. For example, contracts incapable of being performed within a year. So if in 2021, I want to hire Taylor Swift to sing at my concert on New Year's Eve in 2023. And I say, listen, I'm having this big party in 2023. I'm going to book Taylor Swift ahead of time. So I call her in 2021 and I put her on the books. It is not possible for that contract to be completed in one calendar year. She's not intended to perform till over a year from now. So that contract must be in writing. We have to have it writing because it cannot be completed within a year. Additionally, transfer of interest in real estate. When it comes to home sales, parties cannot orally agree to sell their house. That is something that has to be in writing. The courts have deemed it necessary to have a writing under the Statute of Frauds. You cannot sell your home without an actual writing. Additionally, contracts to guarantee the debt of another. So if one party, let's say they want to rent an apartment, and they go to their landlord and they say, I promise that I'll pay you $1,000 a month for my apartment. And the landlord says, I'm not sure that you're going to be able to pay. I don't trust you. And she says, well, I will get a guarantor. That is somebody, maybe it's a parent or a friend or a boss or someone that says, if this person can't pay, I will pay. I promise I will pick up if this person can't make their rent 1 month. That's called a guarantor, and that agreement must be in writing. We have to write down that agreement saying, I promise to pay this debt of somebody else. And so these are some of the times that the court specifically says we have to have a writing. It's not sufficient to have an oral contract. So Mitchell here says this was just oral, and she tries to argue that this is one of those circumstances where we had a contract that must be in writing. That finding an oral contract here is a violation of the statute of frauds. Mitchell says this was a promise to answer for the debt of another. Because the arrangement to cover Domingo's share of the lottery tickets was $17, was a debt that Domingo owed the group. She says Domingo owed $17. If she wanted to participate in this lottery pool, she had to pay. I, as the person covering her costs, am guaranteeing her debt. If she doesn't pay, I will. That's what covering her costs means. At least that's what Mitchell argues. And she says, so therefore, as we just mentioned under the statute of frauds, the cost to cover a debt of another must be in writing. And she says, because this wasn't in writing, we don't have a valid contract here. And the court says, good try, Mitchell. It was creative, but we disagree. For number one, her argument presupposes that she informed the group that Domingo had been invited to play for the drawings. That in order for that to be the case, then the group really had to be counting on Domingo's money. That in the same way that a landlord counts on your rent. If the group had said, if Domingo doesn't participate, if she doesn't give her money, we're not going forward. But that really wasn't the case. There was no evidence that the group even knew that Domingo had been invited. And so the group really wasn't dependent upon Domingo. And therefore, because of that, Domingo really didn't owe anything to the L group. We can't say that this is a debt that she owed to the group because the group was going to buy the tickets with or without her. She really didn't owe it to them. And because her financial obligation was her contractual obligation to reimburse Mitchell and not a promise to answer for another, this contract is not covered by the statute of frauds. So the court says it was a good try, but that's not really what a debt to promise to pay the debt of another is about. And therefore, this contract is not covered by the statute of frauds. So having an oral contract is sufficient here. That's where the court came down. That we have an offer, we have acceptance, we have a meeting of the minds, we have consideration, and this is not the kind of contract that requires to be in writing. An oral contract in this instance is sufficient. So we'll take a look at the conclusion, and the court says, viewing the evidence in the light most favorable to Domingo, she presented more than a scintilla of evidence. All she needed to show was just a little bit of evidence, and she showed more than that to raise a genuine issue of material fact on whether the parties entered into a valid oral contract and whether Mitchell breached the contract. Remember, the issue here was, should Mitchell have been granted summary judgment? Should we have said, hey, Mitchell, you win. There's not enough evidence here to even look at whether we've satisfied each element of the claims. You win. And the court says, actually, there is enough evidence here. We're not going to say that Domingo actually wins. That's not the goal of this court. But we are going to say that she's presented enough evidence to show that there might be each one of these elements. As such, Summary judgment is improper, and this case is remanded, means sent back to the trial court on the breach of contract issue. You go back to the trial court and you try and argue there that you actually had a breach of contract. This was the case of Domingo versus Mitchell. An interesting case, taking a little bit of look at contract issues, statute of frauds issues, and when we have a valid contract, as well as the proper standard for when we want to review our motion to dismiss or in a no evidence motion to dismiss. Thank you for listening to our Law Shelf case study, and we hope you enjoyed this video.